This is between this honorable court and the Office of the Public Defender. However, we do want to inform that.
The court, for its part, also does not believe there's a conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case. Side up. People State of Michigan versus. I lied. Chair Chastity.
That's me. That's me.
I'm going to see you.
All right. Hello, Ms. Newman. Can you state your name for the record for me?
My name's Chastity Newman.
All right. We're trying to find your attorney.
Okay.
I don't know. Get over it out there. So I know I'm done trying to do all my life.
Good morning, Your Honor. Christina Saxon for Chastity Newman.
All right. She's already identified herself. Court has before the plea form that indicates going to be pleading guilty to the charge of retail fraud 393 offense. Upon a successful plea to that charge, count one would be dismissed. Prosecutor is recommending a fines and cost sentence, and that restitution be held open for 30 days. That's the court's full understanding of the agreement.
That's correct.
Your Honor, we are asking though for time served. Ms. Newman is in Huron Valley's prison and until May of next year. Then will be transferred to Indiana State Prison for more than a year. So given that much time, we ask for time served with a waiver of all but the statutory fees rather than fines and costs.
So everybody's agreed to a fines and cost sentence, but now you want to change it.
Actually,
People have no objection to that, given that she's going to be serving time and leaving.
we had discussed it.
It's what I was going to do anyway. So I don't know why you, yes, I do nice things occasionally, Mrs. Sachs.
We're still learning one another, Your Honor.
What'd you say?
We're still learning one another.
Oh, no, I got you pegged.
I did.
I don't. You might be learning me. I got you pegged. Ms. Newman, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, state your name again for the record, please.
My name's Chastity Lynn Newman.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud third degree. That is a punishable by up to 93 days in jail. $500 fine plus court costs. Fine could be increased 3 times the value of the amount taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
I plead guilty.
Now you understand that by pleading guilty, you'll not have trial of any kind.
Yes, sir.
You signed or had signed on your behalf an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up those rights, including the rights in paragraph 5, which are your trial rights.
Yes,
Do you
sir.
understand? All right.
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole? That'd be a no.
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're indeed guilty of this offense?
Yes, sir.
On the date of November 11, 2021, at the location of 5450 Carpenter Road in Pittsfield Township, Washington County, state of Michigan, what do you do at the Sam's Club that makes you think that you're guilty?
While the store was open, I went in and I took merchandise, passed without paying, and left the store.
Okay. And you indicated the store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take this property, did you?
No, sir.
And the property that you took was offered for sale by Sam's Club?
Yes, sir.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, sir.
Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Ma'am, anything you want to say before I impose sentence?
No, sir.
All right. I will sentence the defendant to the statutory minimums of $125, 93 days incarceration, credit 93 served, and restitution will remain open for 30 days. Anything further?
Nothing.
That on my own.
You're doing pretty
Oh.
well. With the good work.
Well, thank you. Right. That's no. It's Saxon. No, I wanted to take offense. Ms. Newman, thank you.
You're welcome. You have a blessed day, sir.
You do the same.
Thank you very much.
Court calls the case, People versus Antoine Reed.
Your Honor, Raymond Cook for the people.
Good morning, Anna Christina. It's approaching
Who again? Ain't
because I want to make your day.
doing so well. Your name, sir?
Antoine Reed, Your Honor.
All right, what are we doing?
Your Honor, prosecution and I have agreed to an adjournment on this matter so that they can obtain more information.
During this matter to September 2nd, 2026, 9 a.m. If that date works for you, Miss Saxon, or if you out of
Yes.
town again. Really? Okay.
For us.
Thought you may be traveling again, as you always are.
Life balance, Judge.
All right. Bond. Court does call the case, People versus Jason Braswell.
Your Honor, Raymond Cook. Good morning, Your Honor. Zach Waita on behalf of Jason Braswell, who stands at the podium to my right. Please introduce yourself to the court.
Jason Braswell.
I have before me a plea form that indicates that the defendant would be pleading as charged to operating while intoxicated, the 93-day offense.
That's correct.
That's the court's full understanding.
That's correct.
Yes, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name, please.
Jason Braswell.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days in jail, a $500 fine plus court costs. The court could order any rehabilitative services the court deems necessary, as well as community service. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Sir.
Any question regarding any of those rights? No? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights. Part of a trial, you understand that by pleading guilty, you'll be giving up those rights as well as all the rights in there.
Yes, sir.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
Yes, sir.
Has anybody promised you anything other than what's been stated here today, which is nothing, to get you to plead?
Sorry, repeat. Sorry.
No, sir. Has anybody promised you anything to get you to plead? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
November 14, 2022, at the location of Ellsworth Road near Carpenter, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle? Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did, yes.
What'd you have and how much?
I had beer and mixed drinks, several throughout the day.
Mixed drinks with alcohol?
Correct, yes.
Kool-Aid's a mixed drink. All right. Were you stopped by the police or was there an accident?
Stopped by the police.
Why'd they stop you?
Speeding.
Are you disputing the right of the police to stop you in this case?
No, sir.
Were you ultimately arrested?
Yes,
Were you taken to the hospital?
yes.
And was there a blood draw? And what were the results of that blood draw?
0.18 will stipulate to.
0.18.
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
No, sir.
All right. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendants referred to probation, or I'm sorry, referred to Von Swartz for alcohol screening and assessment. Sentencing in this matter will be September 9th, 2026, 9 a.m.
Your Honor, I have a in-person matter in Detroit.
Sorry. Okay.
Is it possible to do
Another sentencing
the
day.
16th?
No, we don't do it every week. We can do August 26th.
Your Honor, at this time, I have a trial beginning August 25th. I apologize. Well, September 9th
Oh,
was,
no, we'll work around your schedule.
I know.
September 3rd.
I can't imagine that.
September 23rd.
September 23rd? That would be fantastic if you could. I appreciate the accommodation, Your Honor.
I didn't even do anything. I said nothing. And apparently the state we're going with. What date was that again? September 23rd, 2026. Is that at noon or 9?
9.
9 a.m. Thank you, Ann.
Thank you very much to you and your staff. I appreciate it.
Bond with its conditions will continue. Thank you. That's all done. Court calls case, People versus Thomas Cheris.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Brian Montoya with it on behalf of Mr. Charis, who's approaching the podium.
I couldn't
Record.
buck a bitch. I reckon.
Thomas Stephen Charis.
Thank you. I have before me a plea form that indicates that the defendant will be pleading to an added count 2 of operating while visibly impaired, the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's for Your Honor. We're set for Raymond pre-trial. I'm not sure if we need to get.
Oh, were we?
And with respect to the Raymond, Your Honor, we waive formal reading and stand muted this time.
Why? Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
Here's the move on. Please.
All right. I have read the agreement. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Thomas Stephen Charis.
Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail and $300 fine plus court costs. Court could order community service and any rehabilitative programs the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor, I do.
Understanding that, do you still wish to plead guilty
Yes, Your Honor.
to that charge? How do you plead?
Guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Understand that, Your Honor.
Signed an advice of rights form?
I'm sorry, Your Honor.
Sign an advice of rights form?
Yeah, that's the one we filled out.
Yes, Your Honor.
Questions regarding any of those rights?
No, Your Honor.
Copy on the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on there.
Yes, Your Honor, I understand that.
and that you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, I am, Your Honor.
and of your own free will
Yes, Your Honor.
because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of April 25th, 2026, at the location of I-94 near Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor, I did.
What'd you have and how much?
I had 3 beers over the course of about 2.5 to 3 hours. 6 or 7 hours earlier than that, I had a glass of wine with dinner.
Were you stopped by the police or was there an accident?
I was stopped by the police, sir.
Why'd they stop you?
The officer, the state trooper, observed me weaving in my vehicle.
Are you challenging the right of the police to stop you in this case?
No, Your Honor.
Right. Were you ultimately arrested?
I was, Your Honor.
Were you taken to the hospital?
Yes, sir.
Were you given a blood test?
Yes, sir.
And what were the results of that blood test?
09, Your Honor.
0.09. Sir, do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
I understand that, sir.
Counsel, are you aware of any other promises or other inducements which have led to this?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
You have.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendants referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing will be, are we sure? Mr. Montoy, does September 9th work for you?
It sure does. What time are we talking?
Wow, see, he's so nice.
You're saying 9 at 9?
Yes, sir.
Now you're talking.
September 9th, 2026, 9 a.m. As to bond in this case, I will set the defendant's bond at a $10,000 personal recognizance bond. Sir, I'll now order standard conditions, including no assault behavior or possession of any weapons, under no alcohol, recreational marijuana at this time, or any illegal drugs. And that's it. I'm not going to. It's an 09. We're good. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Andrew Newman.
Your Honor, reading the code for the people.
Morning, Your Honor. Brian Fennick appearing on behalf of the defendant, Dr. Andrew Newman, who appears to my right.
Your name, sir?
Andrew Newman, Your Honor.
Thank you. All right, I have before me a plea form. Indicates that the defendant will be to an added count 2 of operating while visibly impaired, to 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Correct, Your Honor.
May I have him sworn?
Right here. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
I swear.
State your name, please.
Andrew Newman.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days jail, $300 fine plus court costs. The court could order you to perform community service or any other rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, I understand, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form?
I did, Your Honor.
Any questions regarding any of those rights?
I have no questions, Your Honor.
All right, look at paragraph 5. See a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty pleading guilty, you're giving up those rights as well as all the rights of action.
Yes, I understand, Your Honor.
You understand you're giving up your right to appeal of right. Are
Understand,
you on probation or parole?
Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will? And also because you believe that you're indeed guilty?
Yes, I do, Your Honor.
February 28, 2026, at the location of I-94 near Ann Arbor Saline Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor? What'd you have and how much?
I had 2 beers and about 2 glasses of wine, Your Honor.
All right. Were you stopped by the police or was there an accident?
There's no accident. I was stopped by the police, Your Honor.
Why'd they stop you?
Failure to maintain my lane.
All right. Are you disputing the right of the police to stop you in this case?
No, I'm not.
All right. Were you ultimately arrested?
Yes, I was.
Were you taken to the hospital?
Yes,
Was there a blood draw?
there was.
And was the result of that blood draw 0.155?
Yes, it was, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, I do not, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, it was, Your Honor.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand, Your
All
Honor.
right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
None, Your Honor.
Have I complied?
Yes, Your Honor.
You have, Your Honor.
Or will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Now, here's where we have problems. Sentencing will be. Counsel, will that work for you?
That'd be great, Your Honor.
All right, wonderful. September 9th, 2026, 9 a.m. It was Saxon causing all the problems. All right. Bond with its conditions will continue. Thank you, folks.
Thank you, Your Honor.
Court calls the case, People versus Shana Scipio. I said that all wrong. Yeah.
Thank you, Sonny.
Bring it for the people.
Your Honor, David Udoy on behalf of Shayna Casiopo.
Casiopo, exactly how it's.
It helps me if I do this when I say
Is that right? Okay, I'll see if that works for me. Ma'am, your name?
Shayna Casiopo.
And this is the arraignment. As to the arraignment, counsel, do you waive formal reading?
waive the formal reading, stand defendant mute at this time, Your Honor.
Defendant every waive formal reading, standing mute. Court will enter a not guilty plea. And what do you want to do in this case?
Your Honor, we're requesting pretrial in approximately 30 days. I've had discussions with the people. I believe we are working towards a resolution. They'd like to see a mediation letter. Ms. Casiopo has been doing a lot of treatment, quite a bit of positive things, and I'd like to submit a letter to the prosecutor. So I was requesting approximately 30 days. I don't know if that September 9th date works.
No. See what happened. People start picking their own date.
I just heard September 9th. I was like,
September 2nd work for you, or I have the 16th.
Yes.
I can do the 2nd or the 16th, whatever you prefer, Kelly.
on the 16th, will that be in the morning?
We're hoping. Is it?
Yes.
See, I know nothing apparently. Yes, it will be.
Let's go with the 16th.
16th?
And just a question, Your Honor. Oftentimes with Your Honors, I know the felony docket, like the week of it, we get different times throughout the day, or
Correct.
does this work like that, or is it for sure?
Yes, all my dockets work that way, but you need a morning time.
I actually later it would be better. I have a conflict at 9 a.m.
Okay, so we make a note of that.
Yes.
16th, we can put in just as late as we can on that.
Thank you very much, Your Honor.
Bro, see, I'm a nice guy. I try. I'm not going to do it. Adjourn the matter to September 16th, 2026. I'll say at 9 a.m., but we'll put that later in the date. As to bond in this case, alleged BAC.
.242, there was no crash, no known priors. I wouldn't know that I will likely be submitting an amended complaint. I believe the date of offense indicates this is 2006. It should be 2046.
It was actually, the complaint was amended at the time of its swear to.
Okay.
Nice. Actually by Officer Cole. It was. All right. I will set the defendant's bond, given all of that, at $25,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons. There's to be use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, ma'am?
Yes.
I will also order that the defendant report to community corrections for placement on the sober link testing.
May I make a request as to that, Your Honor? I'm not sure if this is something that Your Honor would allow. I've had Miss Casiopo, I advised her, this case took quite a while to charge. I advised her to get on a SoberLink device prior to this arraignment through EMS tether services out of Hazel Park, Michigan. Would the court consider allowing her to just continue testing at specific times on the SoberLink device, and I can provide that proof to the court? They work with many courts around the Oakland County area.
Oakland? At Oakland. Is that what he said? We're in Washington. Yeah. All right. Any response?
I believe when Mr. Joy and I were talking, he indicated that the defendant's currently testing once per day on that device. As long as that is twice per day, I would have no objection.
And my standard is times a day. So if that increases to 3 times a day, and she will still have to report over to community corrections. So what I will do is I will indicate that I will allow her to use the testing device provided testing is increased to 3 times per day, and that the results are sent directly to community corrections. Now, I've never done it with the SoberLink, so I don't know how that may work. And it may be something that the other agency has to either allow her to see or them to see, or if they're going to send them, however that works out. If that will not work for community corrections, then she would have to come off of the other device and get on our device.
Very well. Thank you very much for making that allowance, Your Honor.
All right. Thank you.
Thank you. Have a great day.
Court does call the case, People versus Christopher Beller.
Your Honor, Raymond Cook for the people.
Good morning. On behalf of Mr. Fowler.
Oh, good morning. Didn't know if you were going to talk to me today. Okay.
Working. However,
Yes, he's right here. He's right up here. Mr. Beller, state your name.
Christopher Beller.
Everything's a shock to you.
I know. Well, Mr. Beller, I attempted to contact you. Can you call the public defender's office and update your phone number, or is email the best way to get in touch with you?
Email, but I had some troubles getting on it this week.
Okay.
I'll adjourn the matter to September 2nd, 2026, 9 a.m.
If you call the public defender's office, they'll transfer you to me, okay?
Okay, thank you very much.
All right, thank you, sir. Court calls the cases of the People versus Sherman Booth.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Booth.
State your name, sir.
Sherman Booth.
Your Honor, briefly, we're here for two cases today on the docket. I was looking in our file as well as in JIS, and I believe there may be a clerical error here. We only have one case in our system for Mr. Booth. In looking at JIS, both cases have the same date of offense, same charge, same officer. It's a one-digit difference in the report number. So I believe that something may have been accidentally filed twice, and there was a typo or a clerical error in files. The only case that I have in our system is the file ending in 0746.
This is for today.
Seriously? So you don't have 0659?
Correct.
That's weird. For a number of reasons. Let me just check.
Which one have we been up to? Which one was the audio?
I think it indicates either rained on the file ending.
And the only reason that I say that is because the file that you have in your system of 0746 is set for arraignment today.
Yes, because I believe the defendant was arraigned on the other case back in July 15th.
Correct. On July 15th. So,
And further, the report that I have is the report ending in 598. Report that goes.
your report number ends in
598.
really. Interesting. $598.
Correct.
Okay, so I don't know what poor Officer Cole was doing that day. However, the complaint was amended to reflect the 598. So let's say that clearer. The report in 0659, the complaint was amended to reflect the report number ending in 598. So go ahead.
If that's the case, the court has the 598 as being the correct one. It seems to me then dismissing 0659, since it's a duplicate charge, would make the most sense since we have the correct number on 0746.
I saw that caused you pain. It's me too. Because Cook always comes up with these solutions, but that was not what I was expecting to hear.
Is Your Honor saying on 065?
Yeah.
But all the numbers are so, this is a bunch of lawyers dealing with numbers. So on 0659, Your Honor is saying that the officer amended the complaint to make the police report accurate. So that
Correct.
that he's already been arraigned on is accurate.
That he's already been arraigned on. I think the problem, so that's what I thought. I would think that I'd retain that case and then the other case would be dismissed. However,
That's fine by me.
will you be able to correct that in your system?
We can find a way to do that, I'm sure.
So in other words, I don't know, but I'll give somebody.
I'm not tech savvy enough to understand the inner workings of our system, but I trust it be able to make that work. So.
All right. So what I will do is 0746 will dismiss without prejudice. And I'm going to do that on the court's motion rather than as a nollie. And then we'll proceed after all of that. What are we going to do on the case that now still lives?
Well, we're asking for an adjournment. This case involves phone records, so we are looking at any phone records. It was an investigation.
Yeah, that's nice. Well, is that going to take you time? Is that what you're trying to tell me, or what are you trying to communicate to me, Miss?
Yeah, unfortunately, we're at the mercy of Metro PCS, so I'm not sure how long that may take, but you know, I have no issue really coming back this second. I mean, that's.
Why don't we try this? I'll set it out to the 16th.
Okay.
September 16th, 2026, 9 a.m. That way you give you time to try to get those records. Okay.
Thank you.
All right. Thank you, Mr.
Thank you.
Court calls case People versus Dana Donovan.
When you're on Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Donovan. Say your name, please.
Dana Donovan.
All right. I have before me a plea form that indicates that the defendant would be pleading to an added count 2 of operating while visibly impaired, the 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
Correct, Your Honor.
And her sworn.
Right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So be God.
Yes. Dana Donovan.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, a $300 fine plus court costs. Court could also order community service in the rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. Should copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
January 13, 2026, at the location of Michigan Avenue near Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
What'd you have and how much?
I had 3 drinks. It was 2 beers and 1 shot, sir.
All right. Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
Failure to use my turn signal.
All right. Are you disputing the right of the police to stop you?
No, sir.
All right. Were you ultimately arrested?
Yes, sir.
Were you taken to the hospital?
Yes, sir.
Was there a blood draw?
Yes, sir.
And were the results of that blood draw 0.102?
Sir.
Do you have any reason to dispute those blood test results?
No, sir.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be, I know what days you're here. September 9th.
I'll be there.
2026, 9 a.m.
Thank you.
Bond with its continue. Thank you, ma'am.
Thank you.
Court does call the case of the people versus Tony Gomez.
You're on Raymond Cook for the people.
Oh. I'm sorry, Your Honor. I have one thing that Ms. Donovan and I spoke about. Thank you for stopping me.
Started talking. Came back. I finished.
I know, I apologize.
Let's talk.
This is kind of a big deal for Miss Donovan. It's regarding her license.
Raises its level of importance to me.
Well, for me and my client. I'm so sorry.
Okay,
Thank you.
not a problem. Poor Alan had to bring the file back.
Thank you, John, for your steps. So the issue that I was supposed to bring up is Miss Donovan's.
This is gonna take a while.
No, I'm gonna be really fast.
Oh, go ahead.
So Miss Donovan's license was suspended because she failed to appear at her first arraignment.
Correct.
For like address issues. That's beside the point. She's now obviously been here. She's tried to get, she wrote a letter to Your Honor asking if she could get her license back. It was denied. I am not super.
You wrote a letter to me?
That's what the clerks told her to
Yes.
do, to write a letter to ask you. I've never heard of that.
It was back when I came in to pay for my bail.
And then,
I had a warrant out, so when I came in, they told me I could write a letter requesting that to pay a reinstatement fee. And then I called the next day and they told me it was declined, Your Honor.
yeah.
Did we get a letter? I don't. How'd you send that to me?
I came here to pay the fee and they took it and they said they were adding it to my file and going to give it to you. And I was to call next day.
Does it?
My employer also provided a letter.
I see. I now see it. I don't remember. Yeah. Okay, what I did is I didn't decline it. What I did is I gave no response because you had not been arraigned at that point.
Okay.
Okay, so they probably should not have told you to do it that way.
You've never heard of a letter being.
Pardon?
The reason why we're bringing it up is
It's just their default. Just send
send a letter.
Yeah, I don't.
Okay.
I have my reasons why that happens, but I'm not going to say them out loud.
Gotcha. So I guess at this point,
Unless you want me to. It might hurt some feelings.
we could get into whatever, Your Honor.
Go ahead.
I guess at this point, though, she's been here. The warrant obviously has been lifted. She paid the 10% bond. So from my understanding, all she has to do is pay the reinstatement fee.
My thought is, because we don't, and ma'am, so the judge said, it's usually not something that I deal with in terms of the license, but usually, well, if you get a warrant, license gets suspended. Once you appear, then you're just like everybody else that would have appeared. And so Ms. Perrine, I think, is correct that if you pay the reinstatement fee, then you get a license status that an individual accused of this offense would have. Does that make sense, what I just said? Or no? If it doesn't, that's okay. Tell me, and I'll try to explain it another way.
Oh, who would I just pay the fee up to the?
Yeah, you would have to, I think it's $45.
Yes, that's what I was told.
And so if you pay the reinstatement fee, then your license should be reinstated to the point to a point similar to that if you had not had the bench warrant. That's my understanding.
It's like a license specific that they give specifically for people who are alleged to have committed. Well, now you're not alleged, but when you were arrested, alleged to have committed a drug driving case or OWI.
Correct. Now the problem.
But you have.
Hang on.
Most.
The only thing that I'm concerned about is. Will that happen now that she's entered the plea?
Source factor will go. But the 625 is not going to live until sentence.
Say that again. The 625G,
With actual sentencing. The first abstract.
right.
Yes.
It would what?
But she should still have,
The 625G.
and that will lower, really she needs.
I'm just trying to get to work and back.
No, I know.
Should allow her to get to work, I think. I mean, I know that on a
Here's
600.
what I'm just trying to make sure of. I'm trying to make sure that if we're doing these two things at one point, something doesn't happen. On maybe not our end, but all of a sudden something at the Secretary of State's end.
Right. If you let her pay the $45, right, it would unclear it today. But once the she's gonna get that left. Whenever that hits. So it'll be unsuspended to turn around and get suspended. Yes.
Not, it
Well,
won't,
no, it shouldn't be unimpaired.
yeah. Just for,
I mean, I just don't, what you just said is what I don't want to have happen. And it worries me with all your experience that you even said that, because that's what I'm worried about.
well, if she pays the one good thing is if she pays the 45 today, the abstract that they send them will show that she appeared and that she paid the reinstatement fee, right? So that will lift the failure to appear.
Well, maybe.
Oh,
Yeah, that's what I'm saying. It may do that or it may not. If she had paid, okay, so here's the deal. If she had come in and rather than write me a letter, had set it for arraignment and paid the 45, right? Or the clerk come down and just ask me, can she pay the reinstatement? I'd say, get arraigned, pay the 45. We'd be doing these then at separate times. Whoa. Show up at times. Then I wouldn't be.
it all happening at once.
Yeah. Okay. Let me think this a minute. Yeah. Good morning. How are you?
Good, how are you?
Good. Good morning. Oh, by the way, it's her birthday.
Happy birthday.
Say happy birthday to Razan. Okay. All right. Good. Fair issue?
No.
It didn't? You want, if I make them sing, we'll let it. That would do it. I can't say. Ma'am, do me a favor, have a seat. My staff is going to check with their SOS manual. And then we might, before you pay the 45, or I do anything with this file, we're going to try to clarify as best we can what can happen. Because I get what she wanted to do. Oh, she's quick. Wow. Yeah.
But you're saying it.
I don't know. I don't think on an impaired it's going to.
Yeah, it's just the restricted, not suspension. The health.
Well, did she get suspended and then restricted?
I guess, yeah, now she's suspended because of the.
What do you say?
Sorry, I don't know if I'm helping, but now she's suspended because of the failure to appear hold. Yeah.
Right. First. So it's 90-day research.
Right. The problem is it's going to look like
Oh, she got a violation while on a suspension period.
It's gonna look like her license is suspended. I mean, and ma'am, you did nothing wrong. It's not that, but it's gonna look like her license is
Mhm.
suspended.
Mm-hmm.
If at the time of the plea, something else happens, I think, if at the time of the plea, your license is suspended, it would be suspended. It could be suspended for different reasons, right? But I think something else happened. And so what I don't want them to do is say her license is suspended. She pled to this charge.
Mm-hmm.
And then take whatever action they're going to take. And even though she's paid the 45, I just see this becoming a mess. My opinion.
Could she pay the for?
Why, Karen? Why did you? We were all done.
I know.
We're done. Told me bring the file back, just something quick.
I thought you were just gonna say, pay the 45, we're good to go. So.
Well, if I didn't care about people and what they want to do, I could just say that and then let it happen how it's going to happen.
I mean, it's two separate processes. She's going to go out, pay the $45 clearance fee. That happens immediately.
And that will go in.
And that will go in. Clerks will receive a confirmation before she even walks away from the counter that the suspension is lifted.
Oh,
Then here's what we're going to do.
that's great. Okay.
Before I send the file out, go pay them. It's going to sound weird, but I don't want you to end up in a problem. Go out, pay the 45, come back down to the courtroom. I'll run it. Make sure it's cleared.
Yes.
Then we'll do this.
Okay, so go pay and come back.
I come up with a brilliant plan.
This is a good plan.
I know.
Thank you, Your Honor.
Not a problem. Okay, go down and do that, then come back in, and then we'll see where we are. What? Letting the clerks know what?
That she's coming out to pay the clearance fee, that's okay.
And then tell them to tell her to write a letter. Okay, sorry. Court does call the cases of the people versus Chad Jones.
John Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Jones. Mr. Jones, when you're able to state your name for the record, looks like he's trying to get unmuted.
Yeah, he's trying to get somebody. Oh, Mr. Jones, can you state your name so you can hear me?
Chad Jones.
Thank you. Thank you, sir, for helping him out. I have before me a plea form that indicates that the defendant will be pleading to 2 charges, attempted R&O, the 1-year offense, as well as retail fraud, second to 1-year offense. Upon his success, which is as charged, I do believe, in the case ending in 0685. Upon his plea to that, then the case ending in 0544 would be dismissed. And the prosecutor recommends that they have no objection to credit for time served. That's the court's full understanding.
That's correct. My understanding the defense is going to be in Department of Corrections until at least October of this year also.
Through at least October of this year. Okay.
And that is our understanding as well, Your Honor.
All right. Mr. Jones, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record, please.
Chad Jones.
All right, sir, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanors. The first misdemeanor is attempted resisting and obstructing. That's punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that, sir?
Yes, sir.
And also the charge of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to those charges?
Yes, Your Honor.
Charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of retail fraud second, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form or had one signed on your behalf?
Yes, sir.
You have any questions regarding any of those rights?
No, sir.
You understand you're waiving or giving up all the rights contained on that form, including the rights under paragraph 5?
Yes, sir.
You understand you're giving up your right to appeal upright?
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of these offenses?
Yes, sir.
June 13, 2024, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, state of Michigan. What'd you do at the Meyer store that makes you think that you're guilty, sir?
I stole a bike, sir.
You stole a bike?
Yes, sir.
All right. And the store was open to the public at the time that you did that?
Yes, Your Honor.
You didn't have anybody's permission to take that bike, did you?
No, sir.
And was the bike valued at greater than $200?
I'm not exactly sure what it was valued at.
We'll stipulate that, Your Honor.
Those stipulated $200. What kind of bike?
A mongoose.
Ooh. Mongoose. All right. You're stipulating to the $200. Okay. And you didn't have anybody's permission to take that bike. Is that right, sir?
No, sir.
All right. Well, hold on. We did that wrong. Nobody gave you permission to take the bike. That's correct. Is that right?
Yes, sir.
Thank you. All right. Did you, at that point in time, come into contact with an officer from the Pittsfield Township Police Department?
Yes, sir.
What happened with that?
She tried to pull me over. I took off and
Say again. I didn't hear you. I didn't hear you there, sir.
Once she tried to pull me over, once she tried to stop me, I ditched the bike and I took off.
Okay. So she was coming after you. You're on the bike.
And I took off on the bike and then I ditched the bike.
Okay. Because you couldn't pedal that fast and she could move faster in her car, right?
Yes, sir.
Yeah. Okay. And you dropped the bike and then you ran.
Yes, sir.
And you knew that she was trying to pull you over regarding the theft of the bike. Is that correct, sir?
Yes, sir.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to attempted resisting and obstructing and retail fraud. The case ending in 0544 is dismissed pursuant to the plea agreement. Sir, anything you want to tell me before I impose sentence?
Yeah, I've been in prison for about a year now and I'm trying to get my life back together. So I'm definitely sorry for what I've done.
And when I get out, I'm gonna get a job and change my life.
Okay. How long has he been?
He's been in for about a year, and then he did almost 4 months in our jail as well. I believe.
So he did 4 months in our jail plus
that time in
almost a year
in prison. Yeah.
Got it.
I can give you the exact dates.
No, that's fine. As long as it's over a year, I'm good. As to they got the bike back.
Correct. All property was recovered. I'm unaware of any restitution.
Got it. All right, sir, it's a sentence of the court on count one, fines or statutory minimums of $125, 365 days in jail, credit 365 served. On count two, $50, statutory fees, 365 days, credit 365 served. All right, sir, you're all set. Good luck to you.
Thank you. Thank you, sir.
Good, thanks.
Yeah.
How did I get more files? What did you do? No, I'm not talking to you. Court calls the case, People versus Tony Gomez.
Morning, Your Honor. Raymond Cook for the people.
What'd you do?
Good morning. So the public defender's warrant.
Go ahead, Ms. Perry.
Yeah. Gomez. Well, I don't think it's here, Your Honor. We did attempt to get in touch with Mr. Gomez. We were on.
Gomez. Not here. Here, birthday girl.
Thank you.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give you 10%.
That was fast.
I know I have more. Oh, who are all these? Court calls the cases of the People versus Heather Booth.
Morning, Your Honor. Raymond Cook for the people on the file ending in 0895.
Conrad Silver on behalf of State Stewart Township, other matters.
On all 5 cases.
Assistant Public Defender Nicholas Vukovich on behalf of Ms. Booth.
Good morning, Honor. Jay Grant Miller, P58658 on behalf of Ms. Booth on the Pittsfield matters.
Smooth, can you state your name, please?
Heather Booth.
Thank you.
You're welcome.
You're on. This time, we are requesting an adjournment for about 4 weeks out. We are in negotiations with Mr. Cook on some other state matters that we'll be seeing you tomorrow on. We're trying to get ahead of this and trying to get the Pittsfield Township cases to come after the state cases for purposes of resolution.
What?
We're going to be back here tomorrow with Mr. Booth, with Ms. Booth, Your Honor. So I'm just trying to ask to adjourn the Pittsfield Township cases till after. We're not going to resolve it tomorrow. We're going to be adjourning the matters tomorrow morning, probably 2 weeks out. So I just want Pittsfield to be.
What are you doing on yours, Buckovich?
Yeah, and we are working towards a global resolution for felony matters as well as all her misdemeanor matters. So I would also be asking for an adjournment.
Okay. She's in what jail?
Wayne County.
How long, Ms. Booth, how long are you going to be there, you think?
I get sentenced on the 21st and then I got 6 months released to rehab and 2 years probation and 30 days of community service. I was hoping to get the Fran concurrent if possible. I don't know.
Well, I don't have pleas on it at this point, okay? So I'm just trying to time this out. So you get sentenced on the 21st of this month.
Yes.
Okay. Then my next date I've got is the 2nd. Is that going to give you guys enough time?
I hope so, Your Honor. Yes.
All right. I'll adjourn all her matters then to September 2nd, 2026, 9 a.m. All right.
Does that mean I come to court tomorrow or no?
Pardon?
Do I come to court tomorrow then or no?
Oh, yeah. Oh, yeah. I'll see you tomorrow.
Okay.
Aren't you happy about that?
Yep.
A little bit more enthusiasm, but okay, I get it. Thank you.
It's me out of myself.
We'll see you tomorrow, Ms. Booth.
All right. Thank you. Have a good day.
All right.
Yeah. Give me some. Giving you some in custody.
We have new charges for failure to register, charged through Lebanon Municipal. Also, a positive drug test on July 27th for alcohol. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
I have a lawyer, Joe Osciello, but I
Okay.
haven't been able to get a hold of him yet. My family's trying to do that right now.
Okay. Did you retain Mr. Ocello, or was he appointed for you in your prior case? I don't remember.
Prior case.
Okay.
And an ongoing case in Franklin. I got a court case on the 7th in Franklin.
All right. So you want me to appoint Mr. Ocello in this case, right?
If possible. I mean.
Okay, but I'm so confused. You haven't retained him, right?
Not that I know of. My family's working on that, and I've been out of communication for the past weekend.
Okay, maybe the smartest thing. I mean, looks like we got a sizable bond in Lebanon Municipal Court. I can set this over for another preliminary hearing next week where you'll know more, maybe? Is that what you want me to do? Or what do you want me to do with this case?
Or I can go with the public defender, I guess. I don't know. I'm really not sure. I'm just anxious to get back to work. I screwed up by not registering the proper address after I was moved out of my old house. I was sleeping in my car.
Well, even if I wanted to release you, I don't have that option because you're being held for a different court.
It does look like Mr. Ocello was originally appointed on the case, not retained.
Yeah, let's just go ahead. I'll go ahead and appoint Mr. Ocello to represent you in this case. And we can sort of figure all of that out.
Right there on the
I do find that you're indigent for the purposes of hiring a lawyer in the case. I'll appoint Mr. Ocello to represent you. You have his contact information there. We're also going to send him an email that lets him know that he's been appointed. Do we know what the status of your case is? Your case, what is the case in Franklin? What is that, a different case?
A different case. It was a issue with a friend who was storing things in my garage as I was moving.
Okay, I don't want you to go into the details of the facts of it since that case is still pending. And your case in Lebanon is set for a preliminary hearing next week. Is that still, do you even know what your case in Lebanon is set for?
I thought it was tomorrow.
Oh, okay. Mr. View, do we have any information on that?
When I checked, I do show that we have received the case for review, but it hasn't been scheduled for grand jury yet.
Oh, okay.
So,
Your Honor, I see that a preliminary hearing is scheduled on August 10th. That's what Officer Torek has.
Well, Mr. View says we have the case already, so it must have been bound over already.
I mean, I show that we've received it for grand jury prep, so I don't know if it was referred to us direct from the sheriff's office.
Well, let's do this. What I'm going to do is I'm going to set your case in 2 weeks for a final violation in this case. That way we'll have the opportunity. You can talk to Mr. Ocello. We'll sort out where we are at on all of these other cases and figure out where we're at. Is there anything you want to tell me today?
No.
All right. I do find there's probable cause to believe you have violated the terms of your supervision. I'm going to hold you in jail until the next hearing. I'll see you in a couple of weeks. This is the case of the state of Ohio versus Raymond Slayton, case number 25 CR 43125. Present before the court is Mr. Slayton, right?
Yes, Your Honor.
We have Mr. View from the prosecutor's office, Officer Fisher from probation. We are here today for a preliminary probation violation hearing. Court is in receipt of the report that says that we have new charges for criminal trespassing through Franklin Municipal Court. And we also have a positive drug test on August the 3rd for meth, fentanyl, tramadol, and alcohol with an admission to use of those substances. I may be setting this for a final hearing in about a week to 10 days. Mr. Slayton, you have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
Yes, Your Honor.
You're going to hire one, or do you need one appointed?
One appointed, please.
Given the time frame that I want to set this, I doubt that we can get Mr. Swift available in time, so let's appoint somebody else. Who do we have? I want to get this back on the docket pretty quick. Mr. Swift is sometimes difficult to schedule with, so I want to get this on sooner rather than later.
Thank you, Your Honor.
Who is it?
Justin McMullen.
So Ms. Groko has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. I do find you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Mr. McMullen to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he's been appointed. Anything you want to tell me today?
Sean, I know that I screwed up and I'm going to try and get back into a program and get back to doing the right thing. So.
All right. I do find there's probable cause to believe that you have violated the terms of your supervision. I'm going to hold you in jail until the final hearing, and hopefully we will have some treatment options available to us at that time. All right. That's all.
Denise.
Where are they? I know, I see you. Hey.
I can, I just wanted.
Yeah, I know. I told you she's priority and you are doing whatever you're doing. But yes, here, just do what you got to do.
The stack is.
Alan, you may need to do something with this one. I'll let you know. Yep, you need to stand up. No, I'm not talking to you. Court calls the case. People versus Terry Hayes.
People.
An assistant public defender, Nicholas Bukovich, on behalf of Ms. Hayes, who is appearing via Zoom.
Up there. Ma'am, can you state your name?
Sarah Hayes.
Thank you.
At this time, Your Honor, we ask and set this matter for final settlement conference.
Would you be ready this Friday?
I would be requesting the October date, Your Honor.
Jury final settlement conference will be set October 16th, 2026 at 9 a.m. Jury selection will be 19th.
Yes.
October 19th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. Bond continued. Oh. Oh. It already has.
Mhm.
Did it? Really?
Yeah, for me.
I think we should tell her.
Yes.
All right. Fine. Whenever you want. Really? Mental, no more vacations for Anne. Oh. You just, because you don't know how to act when you get mad. Ms. Donovan? Sorry about that. Anyway, it's cleared. So you can go down, we'll send the file out. You'll go down and get instructions on this because this will go in. Okay? We're all set. You guys have a great day.
Today, just because.
That is not my province. But yes, she should be able to drive, but she'll have restrictions once
Right.
this goes in. But that should include, because you're really trying to drive to work. So I can't guarantee it, but it should include that as part of your restriction. Okay? You guys take care. Don't give her any more instructions. I already told her.
I know.
What do you see? This is how the problem got started in the first place. No, you do what you do. Court calls the case. People versus Devon Julia Martinez.
Conrad still around campus.
And Edward Lucas on behalf of Ms. Martinez in 2108.
And Assistant Public Defender Nick Buckovich on behalf of Ms. Martinez in the other matter.
Your name?
Seven Blue.
What are we doing?
We have a resolution in both matters.
Do I have a form?
It'll be
on both of them? Oh, then I don't need it.
It's possibly changes of the original charter.
Got it. Ready? And Ms. Martinez, that's a correct statement, counsel, of the agreement.
Yes, Your Honor.
Starting the case ending in 0620. Martinez, do you admit responsibility to the fact that on the date of May 18, 2025, Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
I admit responsibility.
Fine. And do you also admit responsibility to the fact that on November 24th, 2025, Clark Road, Pittsfield Township, that you double parked the motor vehicle? Pardon?
Yeah.
You? All right. Court will accept those admissions of responsibility to count 2 in each case. Count 1 is dismissed. Fines and costs of $180 in each matter. But you're not going anywhere anytime soon, correct?
That's so true.
Pardon?
Right now,
I don't know.
held in the circuit court matter, and that's working to be resolved. So we don't have an out date essentially at this time.
All right.
Sorry.
Then what I'll do is I'll just assess them. I'm not going to put a payment plan or a payment time on them or anything.
Okay.
All right. Thank you.
Thank you, Ben.
That's okay.
Welcome. All right. What caused the case? You will first with Jacob Haas.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Hodge. State your name for the record, please, sir.
Jacob Hud. I had to get to it. Slow down. Court has before it a plea form that indicates that the defendant is going to be pleading to retail fraud second degree, which I believe is as charged. The 1-year offense, that is the full understanding of what he's going to do today.
Under HIDA.
Yes.
Oh, I'm sorry. It is sentence agreement of HIDA. Thank you.
That's correct, Your Honor.
That's fair.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record.
Jacob Hodge.
Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased 3 times by the property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed or had signed on your behalf an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all of those rights, including the rights contained in paragraph 5?
Yes.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
All right. Were you on probation or parole at the time of this offense?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of January 16, 2025, at the location of at the Home Depot store on Carpenter Road in Pittsfield Township, Washington County, State of Michigan, what did you do on that date that makes you think that you're guilty?
I went in the store and took items out the store that was for sale.
All right. Store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No.
And the property you took was offered for sale by Home Depot?
Yes.
And was the excess value of the property, was the property valued in excess of $200?
Yes.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Tree?
No,
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Certified, Your Honor.
Okay. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 9th, 2026, 9 a.m. Bond will continue. Sir, I'll need you to wait on the line. We're going to we're going to put you into a breakout room with my probation department so we can start the sentencing process. All right, sir?
Yes, Your Honor. Thank you.
All right. Thank you. Court calls the case People versus Derek Simpson. What are we doing? No relation.
Morning, Your Honor. Marcia Crater standing in for the attorney of record for Mr. Hugo Matt. Sir, can you please state your name?
The record is Derek Allen Simpson.
You have no objection to Ms. Crater stepping in?
No objection, no.
All right. What are we doing?
Well, maybe Mr. Cook and I briefly approach.
Yes. You're requesting an adjournment on this matter?
Yes, I am, Your Honor, till September.
Like we had a brief bench conference. This matter is adjourned to September 2nd, 2009. Defendant's bond in this case will be reduced. All of the conditions previously ordered to apply. I'll reduce his bond to a $5,000 personal recognizance bond. You understand that, sir?
I do, Your Honor.
All right, thank you. Court calls case People versus Pajiter Ivachek.
Your Honor, Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ivachek, who is appearing via Zoom.
Hold on. Good morning.
Good morning, sir. I'll need a camera. I'm doing okay.
Can you?
Oh, there you are. Okay.
Your Honor, we are finishing working on the mitigation report. I know it's been sent over to my mitigation specialist supervisor for review, so I hope to have it soon so I can review it with my client.
I'll adjourn this matter to September 2nd, 2025, 9 a.m. All right, sir. We'll see you then. Have a great day.
God bless you. Have a great day.
And you, sir.
Thank you, Your Honor.
Thank you.
Court does case People versus Grant Decia.
Morning, Your Honor, Raymond Cook for the people.
Mess it up every time, G-Shay.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Doucet.
Correct.
State your name, please.
Grant Matthew Duche.
Again, I messed up his name, but every time.
Your Honor, we're asking to set this for final settlement. Mr. Cook and I discussed it, and I believe he has no objection to this week. We think it's going to be resolved on Friday.
That's correct.
All right. Jury final settlement conference is, what's that, August 7th? August 7th, 2026 at 9 a.m. Jury selection, if necessary, August 10th, 2026 at 8:30. Both of those proceedings are in person. Okay.
Thank you.
Court calls case People versus Rickard Tuccio.
Morning, Your Honor, Raymond Cook for the people.
I added syllables, Artuso.
Rick Artuso?
I don't know if Mr. Burgess is here. I had actually filed them nominated.
It's
or has had an opportunity to review that.
I don't have it, but you're moving to dismiss.
Yes, Your Honor.
All right, Mr. Artuso, you're
Yes.
10 if you want, that's fine. We're gonna have Mr. Kilowald step in for your attorney, okay?
Robert G. Kill on behalf of Mr. Burgess.
All right. And this matter, the people are moving to dismiss it, okay, Mr. Artuso?
Okay.
All right, so this case is dismissed. Thank you, sir.
Okay, thank you.
Okay. Thank you. Court calls the case of the People versus Robin Hessen.
Your Honor, Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich from Ms. Hessen, who is now approaching.
Your name?
Robin Hessen.
Thank you.
Your Honor, the Senate people will be moving to dismiss this matter without a nominee prepped and filed.
No objection from the defense, Your Honor.
Like how this is going. Case dismissed.
I'll go to the defense.
Wow, really? There you go. Court does call the cases of the People versus Dean Hodder. 3 cases.
Your Honor, Raymond Cook for the people, file ending in 0324.
So on behalf of knowledge in the other 2 matters.
Good morning, Your Honor. Robert J. Kill. Judge, I'm on the misdemeanor 241-0324.
And Assistant Public Defender Nicholas Bukovich on the Pittsfield Township matters. Your Honor, if we may briefly pass this matter, I believe we can get this the Pittsfield.
Get pants in the interim?
Well, I cannot guarantee that, Your Honor. However, if we can briefly pass this matter maybe into the next time block, I believe we can get the Pittsfield Township matters resolved today. I just need to get some paperwork ready.
So no,
I want to just,
what are we,
Sorry.
what are we, what,
no, this is the situation. It's my understanding he has a PC tomorrow, a felony. They're hoping to work out a package deal, which hopefully would include my case in this. So I was going to ask for an adjournment on my case. And it's my understanding he's going to plead to the 2 trespass cases in Pittsfield today. But I need an adjournment on my misdemeanor to see what happens with the PD and this felony tomorrow.
I'm looking at you two.
We do have an agreement in the Pittsfield Township. We're just gonna leave it a
Case.
Thank you.
Hold on. So the state case is
Retail fraud.
now, but it's 0324.
Correct.
So that one you want to adjourn. I'll adjourn that matter to September 2nd, 2026, 9 a.m.
Let's see what the felony.
You wanted Mr. Bukovich, really? And
Yes, Don.
come here, please.
What is this? Me misbehaving here.
Next time, more pains.
Fine. All right, so why would I move this to the next time block? You got to talk to him.
It does get the paperwork filled out, but we'll be able to resolve this today.
I'll move it into the next time block. I'll go with Ann. It doesn't seem.
Thank you, Judge. You're very considerate.
Thank finally for the alone. All right, so there. Thank you. Calls the case, People versus Zachariah Haruska Dennis.
All right, so I'm in Pittsfield Township.
Your Honor, if I could just have one moment. Public Defender Lauren Perry on behalf of Mr. Haruska Dennis, state your name for the record, please.
Zachariah Haruska Dennis.
Thank you.
So, Your Honor, I handed Mr.
I'm having a problem hearing. Just hang on. Ain't working apparently.
He's always working hard.
No. Okay, go ahead. What?
Your Honor, Mr. Haruska Dennis completed the In Jail Don Farm program, so I handed Mr. Phillip the completion form, or if you could get that, my client gave me.
And based upon this completion of that program, Your Honor, I'm going to.
Case is dismissed. Thank you.
Thank you.
Court calls the case, People versus Spencer Rassick.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Jay Grant, T58658 on behalf of Mr. Rassick, who approaches. State your name,
Spencer Rassick.
I have a plea form that indicates he's going to plead no contest to the charge of false report of a misdemeanor, the 93-day offense upon a successful plea to that charge. Well, that's the charge, as charged, is that correct? Yes.
Yes, Your Honor.
Plead as charged. There's a sentence agreement to the prosecutor's deferred. That's the court's full understanding.
That's correct, Your Honor.
That is our understanding, Your Honor.
Evan sworn.
Raise your right hand. Solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. State your name, please.
Spencer Rassick.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of false report of a misdemeanor. That is itself a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Correct. Yes.
Understand what a no contest plea is?
Yes.
All right. 2 things about it. I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Basis for the no contest plea?
Lack of specific memory and civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind. You signed an advice of rights form today, is that correct? Any question regarding any of those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 26676. Any objection to the court having reviewed that report?
None from the people.
None from defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in a Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None from defense, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing will be September 9th, 2026, 9 a.m. Bond will continue. Sir, stop down at probation. They're on the left on your way out of the courthouse.
Okay.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Paul Ledford.
Morning, Your Honor. Raymond Cook for the people.
She not have counsel.
This is Raymond pre-trial.
Your name?
Paul Hayes Ledford.
I think they send him for a complaint. You have another matter before me, right, Mr. Ledford? No, hold on. We're checking. Because I think
I am seeing, it looks like there is a felony matter, case number 26-5-5108. It is that for competency hearing on September 29.
That's what I thought. All right. Said September 29th.
That's what's indicated in our notes. I'm just going to double check with JIS to make sure that's the correct date.
All right.
That's fine.
Okay, so Mr. Ledford, here's what I'm going to do. I'm going to adjourn your case out because we've got to take care of the other case before I can deal with this. You understand that?
Yes, sir.
All right. And I'm going to indicate, is the public defender his attorney on that case?
No, I believe it's Burgess.
Mr. Burgess, you represent Mr. Ledford on his other matter?
I do, Your Honor.
Okay.
I wasn't assigned to this one, though.
Yeah. So this wonderful system works like it should. That matter's pending competency. He's got this new matter. So what I'm going to do, Mr. Ledford, is I'm just going to adjourn this out past that date. So hopefully we can get it all taken care of together. Okay. So I need my first date in October.
October
7th. So I'm going to adjourn this matter to October 7th, 2026, 9 a.m. All right. Thank you, Mr. Leff. Court does call the case. People versus Christina Evans, 3 cases.
We are reading on the file ending in 0577.
Henrik Silver on behalf of the township.
Good morning. Good morning. It's Ms. Middleton, Lauren attorney on behalf of Miss Evans. Not here in the courtroom, Your Honor. On Zoom?
You come through.
Oh, great.
Just a mystery to you, Miss. No.
Did you call?
Miss Evans? Christina Evans? Need you to unmute and turn on your camera. Can we send her something? Christina Evans? Oh,
Hello,
state your name.
Christina Evans.
All right. What are we doing on her matters?
Your Honor, on the state case, the resolution was that she's gonna do AA and community service. We hadn't talked prior to today. I wasn't sure if she completed any of that. Ms. Evans, can you let us know?
Okay, here, give me a second.
Well, regardless, then I need to get proof over to the people.
I did do a double A meeting, whatever you call it, AA meeting. I did it Zoom through my phone. I'm still in a few meetings with this church also, doing the double A meetings, if that's what you asked. I don't know, the volume is very low.
Maybe this will help. Your Honor, I guess I'd ask for an adjournment.
Helps with the double A.
The double A. I guess I'd ask for an adjournment so I can get proof of that over to Mr. Cook and have the township cases follow along.
Ma'am, are you still there? Oh, there you are. Okay. So here's what I'm gonna do, ma'am. We've got to get proof that you've done everything. So I'm going to adjourn all of these out to September 2nd, 2020.
Okay, so do you want me to send a screenshot to her, or how do I do it? Record some of the video that I'm on there, or how do I get her the proof?
Ms. Evans, are you at the same phone number?
Yes.
Okay, so I called you and left you a voicemail, and we sent you an email, so you should have the public defender's number. Give me a call or shoot me a text when we're done.
Okay. Okay.
September 2nd, 9 a.m. Thank you. Bond continued. Court calls case People versus Roderick Miller, 2 cases.
It's all around, yeah.
It's all out of control. I want cake. It was on birthday. And ice cream.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Miller. State your name for the record, please, sir.
Roderick Miller. Thank you, sir.
Good morning, Your Honor.
Good morning, sir. How are you?
I'm fine.
Are you?
Look.
You're looking good.
Thank you. I'm much better.
All right.
All right.
What are we doing?
Your Honor, I'm requesting an adjournment. So Mr. Miller has a number of cases. He's released his treatments on all of them.
Okay.
Get him into treatment, and then everything will kind of follow that.
So when are his next?
I think he's scheduled for the 13th. Does that sound familiar to you?
I believe so, yes.
I think his felonies are scheduled for next week.
For next week.
Yeah.
And then
the releases have all been signed. It's just a matter of.
Is it closed at all, or we don't know yet?
I don't know yet.
All right, I'll adjourn these then to the 2nd, then keep tabs on everything and hopefully get him rolling in the right direction. September 2nd, 9 a.m.
September 2nd, 9 a.m.
Yes, sir.
So when you can
take care. Court calls the case People versus Anthony Ferguson.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ferguson. Mr. Ferguson is currently in custody in the Wayne County Jail.
What? He's currently there?
Yes.
They're not here.
They are not here. I did confirm on Binding this morning that he's currently in custody. I did send an email to the court. Obviously, a written needed to be filed, but we did not have time for the written.
Adjourned to September 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case people versus Kawanda K. Thomas.
Morning, Your Honor. Raymond.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Thomas, who is now approaching.
Your name?
Kiwana Clayson, Rose Thomas.
Thank you.
At this time, Your Honor, we'll be requesting an adjournment. It looks like there may be a resolution up in the circuit court matter that may be pending. So we would like to be able to discuss that with
September 2nd, 2026, 9 a.m. Bond continued. Thank you. Court calls the cases of the people versus John Sherburne.
Morning, Your Honor. Raymond. On the file, 1858 and 1859.
Conrad Siller on behalf of.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Sherburne and all the matters. I have been unable to make contact with my client. I cannot explain his lack of appearance today. I would request an adjournment.
Bench warrants will issue for defendant's failure to appear. Bond will be set in the amount of $5,000, 10% on each case. Court calls the cases of the people versus Kelly Klombach.
Your Honor. Raymond.
Good morning. This is Public Defender on behalf of Ms. Kalmbach. State your name, please, ma'am.
Kelly Kalmbach.
Yeah, I attempted to get in touch with Ms. Kalmbach. I'm not sure if you have the same number that you previously had. I don't know if you got my calls. If not, can you call the Public Defender's Office and update your contact information?
Yes, ma'am.
Okay.
All right, I'll adjourn both matters to September 2nd, 2026, 9 a.m.
Thank you.
Bond continued. Thank you. Court does call the cases of the people versus Matthew Wallace.
Your Honor. Raymond. For the people on the file, 0656.
On all four cases.
Conrad Siller on behalf of.
Your name, sir?
Matthew Wallace.
All right. I have a new case that he's got to be arraigned on. Mr. Thomas, you're before the court on I need a DV form. You're before the court on a complaint that alleges that on or about June 24th, 2026, at the location of 2376 Carpenter Road, room 218, Field Township, Washtenaw County, State of Michigan, that you did commit the offense of domestic violence against a Melissa Sue Taylor. Do you understand the nature of that charge, sir?
No.
I'm not saying whether you did it or not. I'm asking you, do you understand what you're charged with?
Yeah.
Okay. There's a second offense notice, which would make this a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that, sir?
Yes.
First question I have for you is, do you want to be represented by an attorney?
Yeah.
Yes. This is a public defender case.
Assistant Public Defender Lauren Perry on behalf of Mr. Wallace will waive formal reading mute the charges, please.
Defendant having waived formal reading standing mute, court will enter a not guilty plea to these charges. You're asking for an adjournment.
Yes, Your Honor.
I'll adjourn this matter to, or set it for pretrial to August, that's a Monday.
Yes.
To August 10th, 2026, 1 p.m. All right. Defendant's bond in this case will be set in an amount of $10,000. I'll give a 10% privilege at this time on that. I will order standard conditions, including no assaultive behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. I will also indicate that defendant is not to leave the state of Michigan without permission of the court. He's not to possess any firearm as indicated, ammunition, or other dangerous weapon. He is not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. I will also indicate that, is there a reason, sir, that you would need to go to, if you were released, to the address of the 2378 Carpenter Road?
No.
A defendant is not to go 2378 Carpenter Road address. Is there any reason, sir, that you would need to have contact with Melissa Sue Taylor? Pardon?
Yeah, she's my wife, my fiance.
At this point in time, sir, I'm going to indicate that you are not to have any contact with Melissa Sue Taylor. You understand that, sir?
Yes.
That contact, when I say that you're not to have any contact, you're not to have contact except with a civil standby. You are not to have or attempt to have any contact, direct or indirect, with Miss Taylor. You are also not to have contact, when I say indirect, you're not to have contact through other persons or by other third parties. You're also not to have contact with by any electronic communication, that is including but not limited to phone, email, texting, the internet, or social media. You are also ordered not to refer to her on any social media or any online form in any fashion. You understand that, sir?
Yes.
You're not to violate any criminal law. You're to personally appear in all court proceedings. You understand that?
Yeah.
Is there anything else?
Your Honor, people will be requesting the court order drug testing if the defendant is to be released. Based on the report indicates that when the defendant was arrested, they found a needle as well as a white powdered residue. They tested that on the came back and so I have some concerns that there's substance use going on.
Any response from?
Your Honor, no objection to that. I will add that Mr. Wallace has released to treatments on all of his files. As you may remember, there's a plan being worked out in circuit court with Judge Conlon for Mr. Wallace to go to transitional housing. He applied, an application has been submitted. So, and that release will also, I can't imagine it wouldn't include any drug testing provisions. So he will be going to treatment if he's released. I would ask that a release to treatment be added on this file. I can submit an order to the court if the court needs one.
I don't have a problem with the release to treatment. I would indicate that I will order drug treatment or drug testing. He would need to test 2 times per week if released. Okay, thank you.
We got August 10th date on the new case. We get a new date for the other 2 cases.
We haven't, but for the other 3 cases. You have 2 or 3?
I only have 2 on the final one.
Okay. All right. And what are we doing on your other cases?
I just have to ask for another date. Mr. Wells is going to see Judge Conlon this afternoon. They're just kind of trucking along to see if he's going to be released to transitional housing.
Got it. So I'll adjourn these to all of these matters to September 2nd, 2026, 9 a.m. Okay. Bond continued. Thank you. Court calls case, People versus Janina Williams. 2 cases.
Morning, Your Honor. Raymond Cook with the people on the file and again 181.
Senator Silver on behalf in case 0 no 5 years old 07.
Custody here. So where is she? Why isn't she here yet? Wow. Wow, and yeah,
Middleton and Lauren Perry on behalf of Miss Williams. Miss Williams, state your name for the record, please.
Janita Williams.
thank you,
Good
ma'am.
morning, Judge.
Good morning.
So, Your Honor, similar thing with Miss Williams. She is going to be released to treatment. She has releases on all of her cases. We're just waiting for a bit. So I'd ask for an adjournment, so that can happen.
All right, I'll adjourn all these matters then to September 2nd, 2026, 90.
Okay.
All right.
Before then, you'll be able to. That's enough sending will be here.
How'd you know? Court calls the case. People versus Janess Kip.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Miss Kip. Miss Kip, state your name for the record.
Good morning, I'm Janess Kip.
Your Honor, I'm asking for another date. We are
what?
doing stuff. We're looking at some things. I'm gonna get some more documentation over to Mr. Cook. We're in
September 2026, 9 a.m. Be Labor Day. Thank you. Bond continued. You got that, ma'am?
Yes, Your Honor.
All right, thank you.
Thank you.
Court call. You're welcome. Court calls the case. People versus Richard Larson. Esplund.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Richard Larson Absalon, who is approaching. State your name for the record, please, sir.
Richard Larson Asplin.
Thank you.
So we talked about setting this for final settlement conference or not. Do you want to do that today?
Repeat, please.
Do you want to set it for final settlement conference today or ask for another date to keep?
I think that we'll ask for another date.
Okay. This case, Your Honor, we're also asking for another date. September 2nd is fine with me.
September 2nd, 2026, 9 a.m. Continues.
Thank you. Thank you. I'll be in touch.
All right, thank you.
Justice.
It is. Weighs on my shoulders every day. Court does call the case. People versus John David Farrow.
Raymond Cook for the people on the file ending in 0384, 06, 03, 0642, and 128.
Connor, so I'll get it, so township can or the other matters.
8, 11, 12, 13, 14, 15. Could have told me that before I counted. On all 15.
Lauren Perry on behalf of Mr. Farrow, who is not present, Your Honor.
Really? Farrow? Right. Warrants will issue for defendant's failure to appear. Bond in each case will be set in the amount of $5,000, 10%. Spread the wealth. Court does call the case. People versus Donald Foreman.
Your Honor, Raymond Cook for the people.
For this is not rated. Yeah, Wayne County. They didn't find anything.
He's well,
Hold on, Jackson.
he's in Jackson.
He's Jackson County. They signed it, but then they signed it.
Oh, really?
Yeah.
All right.
And it's up tomorrow too.
He's up tomorrow also.
Yes.
Is this a PD?
The rating.
The facility having signed off. I'll adjourn the matter.
Does the court have an up-to-date copy of the Secretary of State returns? Indeed, well, depending on.
Oh.
We're supposed to get him there.
He is still suspended.
Thank you.
So I'll adjourn this to September 2nd, 2026, 9 a.m. Oh. Hmm. Hmm. And what? And you didn't, so the pile disappeared. I thought you were just gonna keep them coming.
You won't? I think I covered.
You know what? Sick and tired. She just threw them all up there, made me go through all of them. And then she let me run our file. All right, well. I'm just stalling this. They don't write too fast. What I'll do is I think it's probably an appropriate time for me to take a break and then we'll come back and start the next block. And decides we can. Court will stand in recess.
Does she want to see me now? Yeah. Yeah, tell her to come on in. Okay, off the record, Steve Sealy, everybody. Morning.
Keep it down low.
Your name? Okay, just keep your voice up for me, okay? You're charged with malicious destruction of property. You have the right to an attorney. Would you like an attorney to represent you?
Yes.
Okay, you can go out in the hallway. We will set you up to talk to the lawyer. The lawyer will talk to the prosecutor, and then either way, you'll be coming back in front of me today, okay?
Okay. Can you know me?
I'm sorry?
Just have a seat in the hallway right in front of her. What's your name? What's your name?
Lynette Powell.
You already talked, Mr. Crawford?
Yeah.
Okay.
So this is Woodhaven today.
Yeah.
Oh, boy.
One of those days. And this gentleman here is the sentencing, and he's waiting for Mr. Mays.
Right.
8:30.
Well. Morning, deputy.
I believe we have Tyler Sloan coming in county.
That's who?
Tyler Sloan, I believe, if I'm correct.
Yes, Judge, you got Tyler Sloan and Ashley Wilson. Okay. Okay. Thank you. You're on your way down now. Which one you ready? You ready on this, your Donovan?
I'll read them both, Ross.
Okay, can you hand me the sentencing, John?
Dave?
People against Renetta Sabrina Powell. This is file number 24W 835-913.
Morning, Your Honor. Michael Buck, representing Ms. Powell. Speaking for the record, please.
All right, your client pled guilty. I said I didn't need her sentence report. She pled guilty under to retail fraud under section 771.1. I did not order pre-sentence or screening and assessment. I just set it for sentencing. I've read the report. Is there anything that you would like to say on her behalf?
My client regrets her decision on a particular day. Things have been particularly tight for her and family financially for a while, and just an error in judgment. She's got young children at home, and she just made an error in judgment. She feels really bad about this, Ron. She won't do it again. She, beyond whatever sentence that the court meets out, she's got other issues she's got to deal with. She's on the precipice of starting a new job. That's how she kind of found out about this matter in the first place. And that looks like that's going to be going forward upon. So she's paying a penalty for this, but she's working on turning her life around, pick things up for herself and her family. She got support of her fiance who's out in the hallway, but he's here. With his support, they're going to get through this, Ron. And she just apologizes. She just won't be here for this type of thing.
Ma'am, anything you would like to say?
No.
Well, it seemed like a pretty sophisticated scheme you had going on here. The way you were scanning some, not scanning all the items. I mean, I don't think this was your first rodeo, is what I'm trying to tell you nicely. I'm going to assume it was. Nobody else is convicted.
Sir, ma'am.
Nobody else has convicted you of anything, but you just cannot do this. 9 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. You change your address, place of employment, home telephone number, you must notify probation. You have to report as directed. You're not to enter 23800 Allen Road in Woodhaven or any other Walmart store. I am taking this under the provisions of section 771.1. I'm going to order that you serve 2 days of community service. I'm going to give you until September the 21st to complete those 16 hours of community service. Fines are $100, costs $75, 75 victims' rights fee, $50 justice assessment. So your fines and costs are $300, probation fees are $180 for 480. You have $40 in attorney fees. Your total's $520. You pay that. You do your 2 days community service, you stay out of trouble, you stay out of Walmart, you come back for a review hearing date, and I'll be happy to dismiss this on motion of the prosecutor. So we're going to look, Heather, for I guess it'd be late April. Am I right? No.
May, I believe we did
Yeah, May
9, right?
5th. Before May 5th, I think.
Okay, so then we would actually do the end of April, so April 28th.
April 28th at 8:30, you come back. You're going to meet with probation before you leave here. Can you pay all these fines?
Your Honor, my client can't pay off this day, but we would propose a payment arrangement. They've got $100 they can start with for the day, Your Honor, and they'd like to pay $75 every 2 weeks, starting August the 19th.
That's fine. So $100 today, $75 bi-weekly beginning August the 19th. Now, if something happens, you don't have the money, no problem. Come in and talk to me on it before the due date, or you can call the court if you know how to use Zoom, and I'll be glad to give you an extension, okay? And you'll meet with the probation department. First, you're going to go down and pay your $100. You're going to get your paper notice for for April the 28th. Then you'll go over to probation and meet with them, okay?
Yes, sir.
Best of luck to you.
Thank you.
Daniel Ryan Donahue, 260-841-1850.
Daniel Donahue.
Your client pled to attempted larceny. And the original charge of larceny was dismissed. Have you had a chance to review the pre-sentence report with him, and are there any material additions, corrections, or deletions?
Well, Your Honor, I have had a chance to review the report with my client, and there are no material additions or deletions. My client believes it was being recommended as fair and appropriate and be able to follow through with everything he's got going.
Five or 6 years ago, he was in front of me. I tried to get him in the sobriety court. He's always been respectful and likable.
You've always been great with being there.
Well, I'm not going to be today. You're ruining your life. He picked up another drunk driving. You're in front of Judge Hessen, who told you violated there. I don't know what you're doing. I don't know what you're doing. I don't understand it. Your record's horrible. And you don't comply. I'm told you didn't comply with the order to clear all these warrants. You got warrant out of Southgate, Detroit, Southgate, Lincoln Park, Monroe. I don't know what you're doing.
I don't want to interrupt you.
No, go ahead. You can speak. I'm going to give you every opportunity to speak.
Now, you stated in the past, you gave me every chance in the drug report, and yes, I did follow it. I wasn't ready at that given point. You're absolutely right. Now this was an honest mistake. I lost my phone. You know, I should have returned to the police station. I made the wrong choice, and I own that. As far as that goes, I've been doing everything. I've been working. I know you wanted me to clear the warrants. I'm just trying to make ends meet at this point. You know, with bills, everything going on in my life. I just have full responsibility of what everything that has to happen, but I've been reporting, been dropping, been doing clean.
You just tested positive on Judge Hessen's case for benzos. That's what I've got. I don't want you to comment on it. You shouldn't be commenting on it. I don't understand. It pains me to see people ruin their lives. And it pains me, I feel like, more than it pains the person that's ruining their life. They only give us one of these little things called life. We don't get to go back. And I wish you would have listened to me when I tried to get you in the sobriety court 5, 6 years ago. And then you blew that off. You blew it off. I had to revoke. And since then, you haven't stopped. You haven't stopped. You had another drug offense in 24. You had a larceny of the building in 26. No contest plea to operating while impaired in front of Judge Hessen. Multiple warrants out. I don't understand this. I don't understand. I really don't understand. I get the addiction thing, which I tried to help you with and you blew off. You are what, 34?
Correct.
Still could have 50, 60 years ahead of you.
Oh. So sorry to you too, because
you don't have to apologize to me.
No.
You don't have to apologize to me.
I just feel bad because you are great and you didn't do a lot for me. And I do feel bad because, in the past, I should have did what I was supposed to. Now I got paid.
100 fines, 125 costs, 75 victims' rights, $50 justice assessment. 350, you're going to serve 30 days jail. You're going to serve 15 more days if you don't pay your fines. I'm going to simply give you until October the 31st to pay all your fines. You're in custody for 30 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I really hope you get your life in order. I truly do. Good luck to you, sir. Have a seat over there. Thank you. Who are we waiting on with this defendant, Heather?
I'm putting her in a breakout room right now, and I just sent John a message. I just need him to either have Mr. Crawford or Graziani take her case.
Okay, and what's her name?
This is Ashley Wilson. Miss Wilson, if you could just accept that invite to the breakout room, an attorney will be with you shortly.
You stay here and tell him so he sees it. Yeah, he's got to set up Ashley Wilson with one of those two guys. Stay seated, everybody.
Yes.
Sadie, she's probably with the prosecutor because she's a pretrial. Also, if you want to let him know that Mr. Mays is on Zoom, he just zoomed in. I just brought him in.
Okay.
Good morning.
Good morning.
Do you think it's okay if I'm on Zoom?
That's going to be the judge's call.
Okay, because I'm about halfway there. I was texting with my client and he's there, obviously.
Yeah,
but I didn't want him to have to wait any longer if it was possible for me to do it by Zoom.
You can speak with the judge when he gets back on the bench.
Okay, no problem. Thank you.
You're welcome.
Good morning, Jeff.
Good morning. How are you?
Good morning. Thank you so much.
All right. Who against Simpson, Courtney Regina Simpson? 2, 6, W843720.
Good morning, Judge. John Graziani, attorney on behalf of Courtney Simpson. Please to my right, please identify yourself.
Hello, my name is Courtney Simpson.
All right, so for purposes of arraignment, does she stand mute and wait formal reading?
That's correct, Judge.
She's a college student?
Yes, at Grand Valley State, and we made this unfortunate.
So she's going to plead under HIDA, right?
That is correct.
Is that what you want to do, ma'am?
Yes, sir.
If you plead guilty under the Home Juvenile Trainee Act, I'm going to go ahead and I'm going to take your plea, send you for a pre-sentence report, set terms and conditions. If you're compliant, then I'm going to go ahead and dismiss it at the end of the probationary term. This would be a non-public record. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty to this, there will be no trial of any kind, and you're subject to possible penalties as follows: up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
So you understand if you plead guilty, you're waiving all these rights on the advice of rights. You're waiving the presumption of innocence. You're waiving the requirement they prove you guilty beyond a reasonable doubt, right? To that charge of retail fraud, how do you plead?
Guilty.
On July 9 of 26, were you at 22600 Amlin Road in the city of Woodhaven?
Yes, sir.
And that was at a Myers, right?
Yes.
What did you do that makes you guilty of this offense?
Took items that I knew wasn't fully paid for and mixed them in with items that were paid for.
Okay, so how did you do that?
Self-checkout.
So you scanned some of the items but didn't scan others?
Yes.
And how much was the property that you essentially, did you walk past the register before you were apprehended by store security?
Yes, sir.
And how much in value did you have of items that were taken without paying for them?
$140.
Are you on probation or parole right now?
No.
And you intended to permanently deprive Myers of that property?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Please accept it. Why are you doing this?
I'm doing this because I am currently, why am I doing what exactly?
Why did you do this?
Oh.
You going to Grand Valley. What are you studying?
I'm studying financial management and business psychology.
Judge, I gave her the Dutch uncle lecture.
Good. All right. Listen, I'm going to go ahead. I'm going to give you a personal bond of $1,000. I'm ordering a pre-sentence report. Who's paying for your college?
I'm currently actually paying for my own school. For financial aid, I am living as an independent student. I lost my mom in like 3 years ago. So right now I am taking care of my grandmother at home, and she's been financially stable enough to even pay for school. So I'm currently paying for myself.
Judge, she does work at jobs, including
Gotta use your God. Okay.
and her aunt's in the back over here.
You're going to spend hundreds. I don't know how much I don't know how much Grand Valley costs now, but it's going to cost you in excess of $100,000 to go there for 4 years. Am I right or wrong?
That's correct.
And you're going to jeopardize your future by taking $140 worth of items. Come on, use your head. I'm serious. $1,000 personal bond. You're not to go near 22600 Allen Road in Woodhaven. No contact with prosecution witnesses. You cannot leave the state. You cannot violate the law. You must appear in court as directed. You understand all that?
Yes, sure.
Any questions? We're going to give you a sentence date. We're going to give you a sentence date, and then you're going to go over to probation, and you'll be interviewed, and then you'll come back on your sentence date, okay?
Judge, is it possible because of logistics that she could do it via Zoom for the sentencing?
I start school in less than a week.
Oh, you do?
Yeah.
No problem. You can do it by Zoom. I'll let you do that. What day do you want to give me, Heather? August?
That'll be,
19th?
yep, August 19th at 8:30.
Is that going to be good for you?
Yes.
All right, so go over, get interviewed, and you're all set. Thank you very
Thank you,
much.
Sheriff.
Good luck. Jeffrey Vance, 267-703-966. Mr. Mays, your name?
Good morning, Your Honor. William Mays on behalf of Mr. Vance. I hope you don't mind that I'm appearing by Zoom. I didn't want Mr. Vance to continue to wait on me.
That's okay. Your name?
Jeffrey Vance?
I'd really rather not do this. I'd really rather reschedule it for a day when you're available to be here in person. This is too serious.
Okay.
So I don't know if you're available tomorrow morning.
I am. Yes.
What time
I'll actually
would you
be
like
there.
me to- What's that?
I'll actually be there.
Okay. Well, what time are you going to be here tomorrow?
Let's say 9 o'clock.
I'll schedule it for 9 o'clock tomorrow. Okay.
Thank you, Judge. I will see you then.
We'll reset it for 9 a.m. tomorrow. Okay. On August the 6th. That's okay, right, Heather?
Yes, that works, Judge.
Okay, and I'm just going to keep the file down here. All right. Thank you. We'll see you here tomorrow. Go get a piece of paper with your notice on it. Okay. Thank you. Thank you, Mr. Mace. All right. I think that's it right now. Have a good day. I'll see you tomorrow.
Okay.
Here. So this will be John. We're just going to keep this Vance case. And these are all going down. Excuse me. So this is going to probation. That's going to heaven. That's the sentence. Sadie, would you just keep this one till?
Yeah.
Beautiful day out there, isn't it?
It is very nice. It's a little chilly in here. They used to say the David Letterman show, the night plate show. He kept it at 62 to keep everybody awake.
Well, I drove in, I had sporadic early. It seemed like a little bit of a fall day when I was on my way in, but that's 7:15. McDonald, Patricia Ann McDonald, I have 26W843713, 26W843712.
These are, you calling both the Cassandra and Patricia here, or just?
This is Patricia Ann McDonald, 26W843713, Cassandra Jean McDonald, 26W843712.
They're companion cases, just so you understand.
Okay, I didn't know that. That was my fault.
Judge, and these are for arraignment, and we had a pre-trial, we've worked out.
Right. Your name, ma'am?
Sure. Now.
Your name, ma'am? Okay, so for purposes of, state your appearance again, Mr. Weinberg.
Thank you, Judge. Scott Weinberg, P4587 on behalf of both Patricia and Smith and McDonald.
So for purposes of arraignment, do they both stand mute and waive formal reading?
They do.
So I'm going to not guilty plea. Now, Patricia is going to plead a civil infraction of nuisance per se.
Correct.
How'd you get that deal?
It was a well-positioned lead arraignment runner, and she has no priors for anything. And there's more than unfortunate issues.
And then Cassandra is going to plead under 771, right?
Correct.
To retail fraud. So do you understand what you're doing, Cassandra?
Yes, sir.
If you plead guilty to retail fraud under section 771.1, the possible penalties are up to 500 fines, 90 days jail, costs are all those. And I'm going to still need, she did fill out an advice of rights. Do you understand that, ma'am?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
Okay. And Patricia, you understand that you're going to plead, your lawyer negotiated where you're going to plead responsible to a civil infraction and nuisance per se.
Yes, sir.
And then the prosecutor is going to dismiss the retail fraud. Move to dismiss, and I will dismiss. Do you understand that?
Yes, sir.
Do you agree to that? To the charge of nuisance per se, how do you plead? All right. And again, you have all your, you understand all your rights, Cassandra.
Yes, sir.
You've read these.
Yes.
To the charge of retail fraud, how do you plead?
Yes, Your Honor.
Were you at the Target store at 23555 Allen Road in the city of Woodhaven, July the 9th at 26?
Yes, sir.
And was that in the afternoon at about 2:55 p.m.?
Yes, sir.
What did you do that makes you guilty of retail fraud?
No,
Hang on a second. She's pled guilty to larceny already.
Well, she had a larceny charge of a family member, I believe it was 8 years ago.
I'm not taking this under, I'm sorry, I'm not gonna take it under 771. I'll take the plea. But I'm not gonna take a larceny when there was already a larceny conviction under 771. And she's got something else here too, doesn't she?
There's a driver's suspended license.
Well, it's not a problem, but what happened to all these other entries? Did she got warrants or did she not take care of these out of Huron Township?
She has no other cases pending, my understanding, and there was anything that was on there might was dismissed or not charged. Now, may I explain something before you?
Sure.
So she's really had no, at least not much action with the law. She has some priors. 8 years ago, she's 36 now. She has, but she's had a severe liver issue for a while. She did have alcoholism. She's had issues with drinking and also medical issues. And she's on total disability for liver disease. She was going through depression and this went to.
Good enough. I'll do it.
Thank you.
You understand everything?
Yes, Your Honor.
All right. So to the charge of retail fraud, how do you believe? Again, were you at 23555 Allen Road in Woodhaven, July the 9th and 26?
Yes,
What did you do that makes you guilty of retail fraud?
I mistakenly did not see.
John, I have one here.
Yes.
Did you have items in your property that you're taking from Target, you tell it that,
Yes, sir.
and you intentionally do it?
No, Mayor.
You intentionally did it.
Yeah, I intentionally did it.
Good.
Wait a minute. I need to make sure I understand. Did you intend to deprive Target of the items without paying for it?
Yes, sir.
Okay, so you intentionally failed to scan them? Is that what you did?
Yes, it was a mistake.
But I mean, you
I
intend,
intentionally did it.
okay. Are you on probation or parole?
No, sir.
Anybody forced to plead guilty?
No, sir.
I'll take your plea.
Thank you.
I'll accept it under 771.1. Ms. Patricia McDonald, I'm gonna go ahead and fine you $165, okay? You're gonna pay the 165. I don't know, so I think I want to learn a little bit more about her. Do you have another case? You have a little case here sometime, right?
I do. We have that one from yesterday, that,
Yeah,
it's coming up.
so when's that coming in?
I think it's the 20.
So if you find out the date, Heather, when's Mr. Weinberg here? I'll order a pre-sentence report and we'll just sentence his client on the same day that he's here on the other case.
The case is with
The items
Mr.
will be
Weinberg is
covered,
with
right?
Judge McNally. Is that correct?
It's September 20th, August 25th, the non-seal.
Yeah, that's fine. There was, all these items were recovered, right?
Yes.
We'll do it August 25th. What time's your exam scheduled?
8:30.
The
As
exam,
it's going at 8:30.
It's at 10:30 on the 25th.
Oh, there it is, 10:30.
well, then let's do this at 10:15. How's that?
Thank you.
Okay? So ma'am, you're gonna go down the hall, you're going to get your notice. I'm talking to you, Cassandra. You're gonna go down the hall, get your notice, then you're gonna go over to probation where you'll be interviewed. And you can pay your money today, the 165.
Yes.
So you gotta just calm down now, okay? I mean, you can't be doing this. I understand, but and I feel bad for you if you've got medical issues at a young age. Pardon?
I got a liver a year ago, a brand new liver.
Well, that's good. I'm glad to hear that. Good luck to you. So you can go down the hall, get your notice, and then over to probation where you'll be interviewed, and we'll see you back here on the date that I just gave you and your lawyer, okay?
Okay, thank you.
Thank you.
Okay, thanks.
Thank you for the consideration.
Thank you.
Going to Hall.
Priority waste,
Good morning, Your Honor.
267-843-910. Good morning, Ms. Trombley. How are you?
I'm doing well. How are you?
Pretty good. Your appearance?
Yes, Elizabeth Trombley appearing on behalf of Priority Waste.
You're going to stand mute, wait formal reading on their behalf on this fill load?
Yes, Your Honor.
And not guilty, please, entered. And we're going to set a pretrial, Heather, for when? Can you do it in 2 weeks on the 19th?
Yeah, that's fine.
August 19th at what time? Heather?
9 o'clock, does that work for you, Mr. Trombley?
Yes, that's fine.
No, August 19th at 9 o'clock, okay?
Thank you.
Have a great day. Thanks,
You too.
Mr. Trombley. Mr. Daniel, how are you?
Doing well, Your Honor. How are you?
I'm doing great. I miss you over here.
I know.
What's going on?
I just have a client with a speeding ticket. So.
Okay. So nothing too earth shattering here, eh?
No, nothing crazy.
Practice treating you well?
Yes. I've been busy and thankful for that. So.
Good for you. Good.
Yeah.
Well, we do miss you over here.
Thank you.
Want to get on our MIDC list, we'll be glad to take you back. Okay. Crystal Ellen Gomer, 26W841345. I don't have your file yet.
Good morning, I'm Michael Crawford, representing Ms. Gomer, who's present.
Okay.
Ma'am, please say your name, right?
Crystal Gomes.
Good morning. So she's going to plead responsible to civil nuisance under 110-106 of the Woodhaven Code of Ordinances.
Correct, Your Honor.
And that's with medical issues with child, documented something?
Yes.
Okay. Yeah, they shouldn't be charging people if they're not going to school because they got medical issues.
That's our position, correct?
All right, ma'am, you want to do this, plead responsible to this?
Yes, I'll be responsible.
All right, to that charge of civil nuisance under 110-106 of the Woodhaven Code of Ordinances, responsible or not responsible?
Responsible.
He's recommending $100 fine. I'll go along with that. Please accept it. And we'll go from there. Can you pay that today, ma'am? All right, I wish you well and good luck with your child with that, okay? Thanks.
Thank you.
Have a great day. All right, I don't have your file yet, Trevor. Who'd you speak with? The Woodhaven?
Yes.
What's the name of your client?
Ubi Karan, Ubi, UBHI.
UBHI?
Yep.
Your Honor.
Good morning. How are you, Mr. Ura? Can I have Mr. UBHI's file with Mr. Daniel? I'll get him out of here if you wouldn't mind having somebody run.
Weigh in right now.
Thank you very much.
Thank you, Your Honor.
Bye. There he is. How you doing, Lieutenant?
Good, Robert.
What's your name, ma'am? Palmer?
The palm.
Okay. So where are you doing most of your practicing in? Let me just take this real quick. People against Kieran saying you Ubi 267-843-212. Your name?
Good morning, Your Honor. Trevor Daniel on behalf of the defendant.
So you're authorized to enter this plan on behalf of your client. It's going to be to impeding traffic, right?
That's correct.
Responsible or not responsible to that?
Responsible.
Please accept it, $150, and I'll have her pay by August the 12th, okay? Where are you doing most of your practicing at now?
So I'm still, my main office is in Northville now where we live. And then I still come to Allen Park once a week or so to meet with.
I mean, your office isn't in Lincoln Allen Park anymore?
I still share space with Gordon Miller, but I moved out to Northville area. So I got a business building out there. So I'm trying to spend most of my time out there. It's a lot closer. But yeah, I'm doing a ton of probate and estate planning work. So I'm doing a lot of that. And yeah, so.
Good to see you. You take care of yourself.
Yeah, all right. You too. Good to see you.
Have a great day.
Thanks.
See ya.
Bye.
You meet with a prosecutor or anything, ma'am?
Got here and they told me to come here after the officer. If you wasn't here, you said have to see.
Can you check and see if we got her file? Do you know what that's up for? Is it arraignment pretrial?
Pretrial.
She's been arraigned already?
Yeah. I might have it.
Yeah, I think they might.
Your Honor.
I don't know if you have it or not. Do you have the file of a Melissa De Palma?
Would you stand by just a hot second, Judge?
Sure, and I think she's here for a pretrial, and then let me know if she has a lawyer. If she doesn't, I'm gonna give her one if she wants one.
Judge, I have Mr. Crawford on that one.
Okay. Who has the file then, Heather? Will Mr. Crawford have it?
It should be with the prosecutor right now.
No, I would like you to set up her, she's in here, my court officer's out, and I'd like to have you set up Mr. Crawford with her if you would.
Straight away.
Thank you. Bye.
Thank you, Judge.
Bye. So ma'am, you can go right out in the hallway. I don't know if he's gonna come in and get you now.
Sit up there.
Yeah, I'll tell him to find you, okay? Is that it? All right. People against Ashley Nicole Wilson. This is 19B135357 A and B and C. And I also have multiple files from that are Judge Hesson's. That's on 19B76861. That's on 19B135325. 19B81428. That's on 21B138751B. Is that it?
That's it, Judge.
All right, so your appearance.
John Graziani appearing on behalf of Ashley Wilson.
Ma'am, your name?
Ashley Nicole Wilson.
So she's going to plead to possession of drug paraphernalia, loitering where drugs are kept, and false information that are assigned to me. That's 19B135357 A and B and C. She's got a building code violation 19B76861. Resist, hinder, and obstruct 19B135325. Building code violation on 19B81428. Drive while suspend on 21B138751B. All four of those, the latter four, are all assigned to Judge Hesson. Once she pleads on mine, prosecutor will move to dismiss, and I will dismiss those here. Is my understanding correct?
That's correct, Judge.
All right, ma'am, if you plead
Judge,
possession of drug paraphernalia, possible penalties are up to 500 fines, 90 days jail, costs, or all those. Those same possible penalties apply to this charge of loitering where drugs are kept. And then if you plead to those and you plead to the false information on 353, 357C, I'm going to dismiss the remaining charges. And I think I've neglected to call one. There's actually 5. There's another one, 19B85777, that's assigned to me, and that will also be dismissed. Is that accurate?
That's accurate.
And if you plead on the false information, the possible penalties are up to 100 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the constitutional right to a jury trial. At a trial, you have the right to remain silent. You have the right to question their witnesses. You have the right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. And we are not going to have a hearing or a trial of any kind. Do you understand that?
Yes, Your Honor.
All right. To the charge, possession of drug paraphernalia, how do you plead?
Guilty.
To the charge where loitering where drugs are possessed or kept, how do you plead?
Guilty.
Charge false information to a police officer, how do you plead?
Guilty.
On July the 2nd of 2019 at 12:14 p.m., were you at or near 24301 Woodland in Brownstown Township?
I was.
And who lived there at that residence?
One of my good friends, Mike.
And did you, were you in possession yourself of drug paraphernalia? And if so, what was it and where was it?
It was in the other room and it was heroin.
Did you?
She had possession of it. You had possession of it. Is that correct? Yes or no?
Correct, yes.
It was yours and it was under your control at one point?
At one point, yes.
And that's where the drugs, that's the drugs. What about drug paraphernalia? Did you have some kind of drug paraphernalia?
In my room, yes.
What kind of drug paraphernalia?
I had a spoon and a needle.
All right. You'd use that to take certain types of drugs, correct?
Right.
All right. What drugs?
I was an addiction on heroin.
All right. And false information. What kind of false information did you give to an officer?
I gave them a different name because I knew I had a warrant out.
Are you on probation or parole right now?
I just got sentenced to 2 years probation for Third Circuit.
Yeah, but you were not on probation in 2019, correct?
No, correct.
All right. Anybody forced you to plead guilty to these 3 offenses?
No, Your Honor.
Please are accepted possession of drug paraphernalia, false information to an officer, and loitering where drugs are. I'm dismissing the building code violation from 2019. Resist, enter, and obstruct. Another building code violation from 19, and driving on a suspended, and also another building code violation, all on motion of the prosecutor. How long has she been in custody now? Since Friday, was it?
She originally was in custody from May 19th, 30th. That's in a separate matter, correct? The River Rouge, but it was a felony.
Boy.
That's enough.
I got out on tether. I went on May 19th, got out on tether on the 30th, and then I had sentencing to July 30th, and I had warrants out for you guys, and they took me to take care of this. But my judge gave me till December 1st to take care of all this because I don't have no felony.
Do you have other holds now?
One in Lincoln Park.
So you still have to adjudicate that case?
Yes.
It's a retail fraud allegation.
Which my parents aren't pressing charges. It wasn't really with me.
Judge, it looks like she served approximately 16. I don't know what's going on.
She's served, Judge, approximately 60 days. The initial arrest on another matter, which was 11 days, May 19th or the 30th. She was tethered out and then was brought into the county jail on July 30th as a result of these charges. And she's currently in custody.
So she's only served on this case about 6 days.
That's correct, Judge. I do want you to realize, regarding her background, she did 28 days in the OPL facility for drug rehabilitation.
When?
Wasn't it in 2024, ma'am?
2024, yeah. Today's my 2 years sober.
And she's currently, Judge, she's currently taking medications. We briefly go over.
Where does she live now? She live in Pagel?
That's my mother's address. I live in South Rockwood with my fiance.
What is your address?
It is east of 6500 East Albane.
6500 East what?
Albane, Albain.
Okay, and that's South Rockwood?
Yeah.
What's the zip there?
Oh my gosh. I'm not from Monroe area, so I'm not too sure. We built
6500
the
East
house there.
Albane, South Rockwood.
Yes.
Well, what am I gonna do with this young lady? You better get your life in order.
I haven't.
Does she work?
Judge, she's indicated to me that she works at the Sisters of St. Mary Rapid Tricks, I believe it's in Riverview. It's actually, I believe it's on Grange Road. Am I correct?
Correct.
It's.
All right, let me ask you a couple questions here. When is your Lincoln Park case scheduled?
They don't have me on a scheduled anything. My fiance tried to come pay the bond for all this stuff when I seen you the first time when I got arrested, and they wouldn't let him pay the bond because I have a lien in Lincoln Park for a little retail fraud that I have to take care of, that I have no bond.
Chuck, what happened is that there was a charge, again, it arose several years ago, with some television set supposedly taken from her parents' residence, and indicated that they would not. The mother indicated she would press charges, but nonetheless, she still has to deal with that hold. This is pretty unusual.
I'm trying to think of what I want to do.
Judge, she did go to Oakdale for 28 days, but and she is taking Suboxone tablets. She takes it once a day. And
she doesn't show up in court though, is the problem.
Right. She does with Hagera, I believe once she was out, she took Brixate once a month to deal with the heroin, a potential heroin relapse. Is that correct?
I never relapsed in 2 years since I've gotten clean.
What I'm saying is you were taking Brixate.
Brixati. I get the shot Brixati. Yeah, I get a shot Brixati once a month from Hagera Health and a match program.
Hold on. I'm trying to think of how I want to handle this. At Lincoln Park, they've got to take you before a judge in Lincoln Park.
Yeah, that's what I was saying.
You've been in there since the 31st, right?
The 30th
of July.
So that was Thursday, but then 4 days, 5 days, 6 days. This is your 7th day. I'm just trying to figure it out. I'm going out of town next week. I don't know that I need to leave her in jail for 2 more weeks.
Judge, I would ask for a tether at this time. She's indicated to me she has been. Most of these matters were from. It's insane, but it was from 20.
I know. Can't imagine them not taking the bond from your boyfriend.
Yeah, he came to pay the bond and they told him no because I have a lien in Lincoln Park.
You don't have a lien, you mean a warrant.
Or yeah, I don't, yeah.
All right, let me think. I still don't know what I want to do with this. I hate to leave her in there for 2 months, but then or 2 weeks, but she's not gonna show up.
I will show up.
You've been playing games with us since 19.
I'm on probation. For Third Circuit, I just got on probation, and I'm on probation for Allen Park. I just got on probation for Allen Park. I'm not playing games. I want to be done with this. I don't want to deal with this no more, Your Honor. My life's changed.
I think I want a screening and assessment. Listen, this is what I'll do. I'm reducing this bond to 3,500 personal on 357 A, B, and C. I'm gonna give her a sentence date. And you're gonna come here then. I can't control what they're doing or not doing in Lincoln Park, okay?
Okay.
We can have her screened and assessed today, Heather, by a probation officer while she's in custody. We're gonna send over minimuses, making sure that we let them know she's out on personal bonds. All those other cases are dismissed. So somebody's gonna have to notify them of that. And then I would think they're gonna release her, or they're gonna take care of the Lincoln Park warrant. I'm not sure why they haven't done that yet. It seems like they should have called over there and had you appear in front of a judge there. In the meantime, I'm gonna give you a sentence date. Heather, why don't we do it 2 weeks?
Okay, that will be August 19th. We can do it 8:30.
At 8:30 in the morning, okay, ma'am?
Okay.
So I'm gonna let you out. Now, I don't know what's gonna happen over there. If you don't show up, you aren't gonna believe what I'm gonna do. I'm telling you. Don't play that game with me again. I'll call the police, I'll have them arrest you, and I would lock you up for the entire 90 days. Do we understand one another?
I understand you, Your Honor.
All right, good luck. Thank you.
Thank you so much.
Don't go anywhere, but tell them, if I knew this, she was gonna be released, I'd just have her come over here.
Judge, this is so messed up because it goes back to 19 and there's even a 20 case.
Yeah, but why isn't, I don't understand why they're not taking her in front of a judge in Lincoln Park. All right, good luck, man. Make sure you show up here, I'm telling you.
I'll be
fair with you, but
okay.
you can't do this again. Good luck.
Thank you, Judge.
Thank you so much.
I believe what probation does with them too, they have a contact over at the jail that they send the paperwork to for a screening.
I get it.
So they'll just send it over to him for her to fill out. If by chance she doesn't get it and she gets released today, then she would have to come over.
Right. So hang tight. But if you don't get screened today and you somehow get released, you gotta come over here and be screened and assessed before your sentence date. So you do it the first day you're out of custody, okay?
Okay. So the first 24 hours but what if Lincoln Park comes and gets me?
Well, maybe you'll be out on that case by then. If not, you notify us in writing or have somebody notify us that you're in custody on the Lincoln Park case so we don't issue a warrant if you're not here on the 19th, okay?
Okay, Your Honor. Thank you so much.
Have a good day. Good luck.
Thank you.
So they should be bringing Tyler Sloan next in her place now, Judge.
So do I walk out?